So
I
first
mean,
of
the
all,
Sixth
now,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering. Under the
No,
Sixth
I heard
Amendment,
you. No, no, nope. Stop talking. All right, the court will call the case of the state of Michigan versus Lindsay Dineski, case number 24S00096.
Tiffany Woods for the people. Allison Muller here on behalf of Lindsay Juneski. Ms. Juneski, can you state your name, please?
yeah, sorry, I was just trying to unmute. Lindsay Dineski.
Thank you. All right.
The hearing opens with immediate tension. Before the courtroom even settles into the case, the judge cuts the defendant off, making it clear that interruptions won't be tolerated. Right away, you can tell this isn't going to be a routine hearing.
Right, we're here for a pretrial today, and are you in possession of all of the documents that your client has filed?
I am, Your Honor.
Okay, can we see counsel in the breakout room? All right, we're back on the record in the case of the state of Michigan versus Lindsay Dineski. You don't need to place your appearances back on. We had a brief discussion regarding all of the filings that were filed, although the defendant has an attorney in this particular case. So at this point in time, we need to make a record of what's going on in this matter, and we can go from there.
The court officially calls the case of State of Michigan vs. Lindsay Dineski. Both the prosecutor and defense attorney announce their appearances, and the judge confirms that the defense has received all of the necessary documents before moving forward.
Ms. Mueller, it looks like your client submitted 4 different filings. First of all, the court has no requirement because we're not a email e-filing court to accept email pleadings. We did do so. Your client was advised that there is a page limit to how much we'll accept for any one hearing. So that happened, and you should be aware that that did happen as well, and that she will need to follow any filing requirements in the future. And I believe that she represented to staff that she had filed those with the prosecutor's office. Ms. Woods is indicating she did not receive them. I don't know whether they were filed with the prosecutor's office or not. Having said that, do you have a copy of the filings that your client filed with the court?
The judge explains that the defendant personally submitted several filings. However, they weren't filed according to the court's normal procedures. The court also notes that the prosecutor never received the documents, creating an immediate procedural problem that slows the case down.
I do, Your Honor. I received those filings were sent to the court, and just now realizing they were not sent to prosecution, I have forwarded those to Ms. Woods.
Thank you.
I sent them to the other prosecutor. I apologize. Her name was Ellie, I think, because that was the one who it said she was the prosecutor for the county. So I just probably sent it to the wrong prosecutor.
So it is a he. That is the
Okay.
chief prosecutor, Ellie Savitt, and they probably did not get sent to the proper place because of the way you filed them.
I filed them the way I was instructed to file them. I called and asked for instructions, and I did what I was told. So I was told that the filing requirements were to email them, and that's what I did. So, and then I was notified after the fact that there was a limit. They made an exception because they didn't notify me. And then I told them I emailed the prosecutor, verified the email. And so as far as I know, the chief prosecutor got them. I just didn't know that I was supposed to send them to the other prosecutor too. I thought, notice to agent and notice to principal. So I thought if I sent them to the main prosecutor, any of the assistant prosecutors would get them. Because I didn't know which one would be on the case today.
Ms. Woods?
Yes, Judge. I mean, I'm just opening up one of the files now. I mean, I would need time to review all of this. I would not be able to. Yeah, I would need time to review all of these, Judge.
Thank you. All right.
Lindsay explains that she followed the instructions she was given and accidentally sent the filings to the county's chief prosecutor instead of the assigned prosecutor. She insists she acted in good faith and believed the proper office would receive them. The misunderstanding highlights how confusing court procedures can become for someone representing their own interests.
So first of all, Ms. Dineski has counsel. So whether or not she should or has the ability to file filings in the first place is something I'm still mulling over because she has counsel. So any pleading should come through her counsel. And
Yeah, they
then,
refused to file it, so,
ma'am, I didn't
oh,
say
I'm
anything
sorry.
to you.
I apologize.
And then, secondly, these are not proper pleadings. They're not filed in the proper format. They're not filed with the proper spacing. They're not filed according to any of the court rules. So
They
that's
don't
the,
have to be though,
ma'am, I
which
just,
I put
they do.
on there.
And ma'am, if you speak up one more time, you're gonna be held in contempt of court.
After briefly reviewing one of the documents, the prosecutor tells the judge she needs more time. There are multiple filings, and she cannot fairly respond without reading everything first. The hearing begins shifting from the substance of the case to questions about procedure.
But I thought this was my hearing. I
Ma'am,
should be able to
ma'am,
speak on my
all
own
right.
behalf.
You're not able to speak on your own behalf unless you don't have counsel, and you need to stop talking. One more talking, it's gonna find you in contempt of court, and I'm gonna give you 15 days. So please stop talking.
The judge points out another issue. Because Lindsay already has an attorney, he questions whether she should be filing motions herself at all. He also says the filings don't comply with court formatting rules. Lindsay tries to explain, but every interruption increases the tension inside the courtroom.
Ms. Woods is indicating that she needs time to look at those pleadings and to be able to respond. Ms. Mueller, what is your position? I haven't heard anything from you today, because she actually has.
Thank you, Your Honor. Ms. Juneski and I did, prior to the last pretrial, discuss. I didn't know exactly what she was going to be filing, but I did understand the basis of her legal argument. Her and I had a conversation where I didn't agree with the grounds for filing. It is correct that I said I would not be filing this on her behalf because I found the legal argument not to be correct. At this hearing, then Ms. Juneski did file these motions, and so I would discuss it further with my management, but I would not be proceeding with these arguments at a hearing if the court were to set it for that. I understand Ms. Juneski does want to proceed with these arguments, and I believe that she's requesting to represent herself if this court sets this for a motion hearing.
The situation escalates dramatically. The judge warns Lindsay that if she continues speaking out of turn, he will hold her in contempt of court and sentence her to 15 days in jail. The warning changes the atmosphere instantly and raises the emotional stakes of the hearing.
Now, Ms. Dineski, are you requesting to represent yourself?
Well, I'm asserting my right to represent myself. I'm not requesting.
All right, then if you're not requesting to represent yourself, then what's gonna happen is you're gonna continue to have counsel.
Well, I'm asserting my right, which is much stronger than requesting. I shouldn't have to request something that I have a right to. It just should be automatic, right?
All right.
Like the Sixth Amendment
It is not
and the
automatic.
Constitution.
It is, ma'am,
Yes.
it is not automatic. So
I
first
mean,
of
the Sixth
all,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering under the
No,
Sixth
I heard
Amendment.
you. No, stop talking. So look, this is the way it's gonna work. I'm gonna give you what your rights are.
Defense counsel tells the court she was aware of Lindsay's legal arguments but refused to file them because she believed they had no legal merit. She also explains that Lindsay wants to argue those issues herself and appears to be asking to represent herself instead of relying on appointed counsel.
And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
So, first of all, what you're charged with is police officer assaulting, resisting, obstructing. It's an attempt. It has a maximum penalty of up to 1 year in the Washtenaw County Jail. Do you understand that part?
I comprehend that that's what you're charging with. I don't understand it because it's false.
Okay. Do you understand that that is what the maximum penalty is?
I do, which is why this is unconstitutional because I was the victim in the case and falsely
Right,
arrested.
The judge asks whether Lindsay wants to represent herself. Lindsay responds that she is not requesting permission. She is asserting a constitutional right under the Sixth Amendment. This becomes the central disagreement, with Lindsay insisting that a constitutional right should not require the court's permission.
What I'm going to do is refer her to make sure she's competent Because at this point in time, if she can't understand and she wants to use a different word, then I guess what I need to do is figure out what.
Comprehend means that I know
Yeah.
what it means. Okay. Understand means that I'm understanding the court, and I am not understanding the court because I'm challenging jurisdiction. I don't need a competency evaluation. I see a psychiatrist every month because I have ADD. So if you would like me to present to you that I'm mentally fit, that's fine. But for you to say that I have to have
The judge explains that before anyone can represent themselves, the court must first advise them of the risks and legal consequences. Lindsay answers carefully, saying she comprehends the charges but maintains they are false because she believes she was actually the victim.
a competency evaluation with no cause because I'm asserting my
There's
rights, that's a
plenty of-
violation of Shearer
there-
versus Cullen. All I'm doing is
Okay.
asserting my right to
Alright.
represent myself.
It's referred for competency. We'll prepare an order so she can be evaluated so we can
Well, I
determine.
object to that. I object
You
to
can
the
object to
competency
whatever you
evaluation.
want to object to, but if you don't participate, then I'll put you in custody until we get an exam done.
The judge orders that a competency evaluation be prepared despite Lindsay's objections. When she protests, the judge warns that refusing to participate could result in her being taken into custody until the examination is completed. Lindsay immediately questions the legal basis for that decision, arguing that there must be a valid legal cause before such an order can be enforced. The hearing ends with the dispute shifting away from the original criminal charge and toward questions about constitutional rights, self-representation, and competency. This hearing quickly transformed from a routine pretrial conference into a heated constitutional dispute. The biggest conflict wasn't about the criminal allegations themselves. It was about whether the defendant could exercise her right to represent herself and whether her courtroom behavior justified a competency evaluation. As both sides became more entrenched, the courtroom grew increasingly tense, leaving major legal questions unresolved. Question for viewers: do you think the judge was simply following courtroom procedure, or do you believe the defendant's constitutional rights were being limited? CTA. If you enjoy detailed courtroom breakdowns like this, don't forget to like, subscribe, and share your thoughts in the comments. Your opinion could spark the next discussion.